Kimberly, Brock Coleman, Grace Fowler, talk with Mr. Ashmore when he gets here. I have a note that she has an appointment at UT Southwestern for a medication check today. So I think we're still dealing with competency issues on her. So there's Mr. Ashmore. Mr. Ashmore? Yes, Judge. On Ms. Fowler, I had a note that she has an appointment at UT Southwestern today. Is what it says? Yes, Judge. For a medication check. Today, it's set for docket call, but Ms. Fowler is still, was she deemed competent or incompetent?
It was incompetent without patient.
Patient restoration.
And so the Anderson Center wanted her to continue at least the medication part of that. That appointment is escorted, and I called ahead last week to bring that to the court's attention. My understanding was she needed to keep that appointment.
Sure, yes.
Her absence is, if there's a mistake here, it's my mistake, not her.
Right. Is she already on outpatient restoration?
That's what she's currently doing. But the recommendation was, at least for that medicine part of that, they want her to continue
Sure.
with those Dallas doctors.
So really, we just need to set her for a status check. So let's go ahead and set her out. This is CR 2333, CR 2334. Are you available on April 26th? If that doesn't work, then maybe we can do May 10th or 12th. May 10th or 12th may be better.
We're here on the status for the portfolio on the 10th.
Oh, 10th. All right, let's do that.
I'll text Chrissy Fowler, who's Grace's power of attorney caretaker. Let her know.
Yes, if you'll do that, I appreciate it. We'll go ahead and set Ms. Fowler for a status on her outpatient restoration. Kendall Miller. Dennis Jones. Jason Mays. Michael Welch. Michael Chase Welch. Mr. Sawyer, do you know anything about Mr. Welch?
Judge, Mr. Welch contacted this afternoon. He said he's having transportation issues. It's on the way.
Okay. Derek Viscoda. Trevor Roden. Katie Wiggins. Josue Rodriguez.
He's in the hall right now.
Okay. Is that who we were talking to earlier?
Yes, Judge.
Shanna Dixon. Is there anyone who's present in the courtroom whose name I've not called? You expect to be on the docket? We have any counsel that's ready on any cases? Mr. White, are you ready?
Yes, sir, I am.
You ready, Ms. Dixon?
Aye.
Ms. Dixon, if you'll come to the podium, please. So CR 21-383, State versus Shanna, Lee Dixon.
Your Honor, Mr. Woodward and I have talked quite a bit about this. I'm gonna ask the court to move this over to God.
So no request for evidentiary.
Judge, I think we're in agreement. We've reached a resolution.
All right, court will find that Mr. White has withdrawn his request for an evidentiary hearing, and the court will set this for docket call. Do you have any requested dates, Mr. White?
No.
Do you know when you're back in April? We've got,
I know from Judge, I think I'm supposed to be here.
May 12th. Any objection to May 12th, Mr. White?
No.
All right, court will set Ms. Dixon then for docket call on May 12th at 9 a.m. Ms. Dixon, once you sign and get the yellow copy, you're free to go. Are we anticipating any contested hearings this morning?
We don't believe so.
Oh, I thought you said a couple, and I thought you were shaking your head no. Yeah, and I think Mr. White, is that all you have
For this,
for this morning?
I got one this afternoon.
Okay.
Are we bringing them over this afternoon?
Yes, sir.
It's just out of order, but it's a request. I need to take care of each and duty. I'll be back at 1:30, but I'll ask the court's permission to be a little bit tardy.
Sure. Are you going to do the plea on Rock Coleman this
So I'm
morning?
gonna go work with him right now, yes, Judge, but I just wanted to bring that to your
Sure.
commission and ask for that request
Yeah.
and
So
honoring a World War II vet.
sure. So you're going to do the plea, and then you'll just be back this afternoon.
Yes,
Yeah,
but
absolutely.
I'll be back probably a little bit late.
Sure, that's fine.
Okay, thank you.
Mr. Ashmore, are your matters this afternoon? Are they going to be contested? Or are we going to have any hearings? So you have a motion. I think you have a
We have.
couple motions to revoke.
We have other, I believe if paperwork's ready, that'll be ready to go. There's,
I see Martin says plea, Vasquez says plea.
those two should be ready to go.
What about Thomas, Rebecca Thomas?
I could not get a hold of Ms. Thomas, so I'm not sure the status of that. We do have,
Stokes says plea, and you said Butler will be a plea?
well, Stokes, we have an agreement on plea of true as to the full scope of adjudication. We may have to ask the court to let us go over for a short evidentiary hearing.
So what time do you think you'll be back this afternoon?
2, maybe even
Okay.
1:30.
Okay.
The deal is at noon,
Sure.
so arguably I could get back even at 1:30. It's just the,
I just want to make sure what 3:30 or 4.
no,
Okay, sure.
it's at 12 o'clock.
Sure.
We're honoring the commissioner's court. And then I'm gonna
Yeah, go ahead and do it, Mr. Coleman. Let's get him done, and then you can take off.
make sure.
Yes, ma'am.
Dennis Ray, just your
It is,
Like if they're not gonna, if they're not. Yes, Jones. You can figure that out. We'll figure out.
For 21-328 State versus Dennis Ray Jones, set for docket call today.
Yes, Your Honor. I've spoken with my client, reviewed all the discovery, I've spoken with the states, at this time, we just need.
And so Mr. Jones understands that if he does not accept a plea offer, the state doesn't accept a counter offer, and we request a jury trial, I'm going to set you for jury trial, and not likely that I'm going to allow him to accept a plea after today. That once we get set for trial, we're going to go to trial. Can't decide the Friday before trial that he wants to take the plea deal. That will, of course, not going to entertain a plea agreement after this. He understands that?
I believe that.
Understand that, Mr. Jones? Okay. All right, court will set Mr. And just for the record, what is the plea offer for Mr. Jones?
I think the last best offer was 4 years TDC. We didn't specifically discuss a fine, but some, our normal fine, probably $1,000, $1,500, something of that nature. We could move on that a little bit, but 4 years is low time wise, we're gonna go.
Yeah, and just looking at the docket, it appears to be a state jail. Does that,
He is,
State that-
we have alleged 2 prior felony pen trips, so he is, as indicted, is a second degree.
all right, you understand that, Mr. Jones, that they've made that offer, you're rejecting that offer today, and you understand the court's not gonna allow you to accept
Yes,
4
sir.
years or less after that.
Yes, sir.
All right, court admonished the defendant, and the court will set him for jury selection. We're gonna begin that jury selection. Tell you what, I'll start you on May 2nd. So, Mr. Jones, you will not be reaching trial that day, but that'll be the first day that you appear on the jury selection docket. You're to appear in the basement, or actually the second floor of the courthouse here. And my staff will be down there to help you with paperwork. You won't go to trial that day. Mr. Sawyer's not going to be required to be here, to be downstairs during that time. He won't be required to be here until your case gets in the top 10. Once it gets to the top 10, then you'll have to be here for that. So you'll show up, you'll check in, they'll give you a new date. You're still on your conditions of pretrial release. You're still ordered to comply with all of those. And I still have a note that, I don't know if you're paying on your older cases, but they keep putting the notes on here as to what you owe. Okay, so you need to make sure you're complying with that. Otherwise, you may end up in jail, not on this case, but on those cases. You understand?
I understand.
Okay, and it looks like, you could be incarcerated for up to 93 days on your old cases. So that's a long time to sit in jail. Understand? All right, so I've set him for jury selection on May 2nd. That'll be at 8:30 on the second floor. Once he signs and gets the yellow copy, you're free to go.
I'm also ready on Jason Lee Mays.
Okay.
And
Do you want to have him? Yeah, if you want to, go ahead and have him sign that. Give him the yellow copy, and he can go.
I just need Mr. Brooks.
Jason Mays. This is CR 2401. Mr. Mays is set for arraignment today.
Yes, Your Honor. Mr. Mays is actually set back on the 7th for arraignment. I had filed a motion for continuance because I was in jury trial in the county. From my understanding, the court had requested he be present, even though the arraignment, because there were some pretrial release issues, so the court was trying to resolve, make sure he could talk to the pretrial about. So I had him here again today. He's going to waive arraignment, but I just want to make sure he was here to resolve whatever issues he had with pretrial.
I'm not aware of any pretrial issues at this time. So, so he's reviewed the indictment.
I've gone over with him, Your Honor. He's reviewed the indictment. He wants to waive arraignment, plead not guilty.
All right, his name is spelled correctly and he understands what he's been charged with.
Yes, sir.
All right, court will find that Mr. Mays has waived the formal requirements of arraignment. Court will set him for pretrial hearing. You have your calendar with you.
Yes, sir.
All right, let's look at either May 10th or 12th.
May 10th.
May 10th. All right, Mr. Mays, you're set for pretrial hearing on May 10th at 9 a.m. Once you sign the notice and get the yellow copy, you're free to go.
Thank you.
So we're just wait on Mr. Welch.
Yes, sir. He's still actually texting me right now.
Okay, good. Mr. Schmidt, Mr. Stevens, Mr. Versace, any of you ready? You ready, Ms. Wiggins?
I am. That's just a modification, Judge, on Ms. Wiggins. And that's
Ms.
another way-
Wiggins? All right, this is cause number CR 15123, State versus Katie Lynn Wiggins. I see here that the state has filed a motion to withdraw its motion to revoke and to continue on community supervision. Court finds that Ms. Wiggins has entered into an agreement to amend the conditions of her community supervision. Ms. Wiggins, you've gone over this with your attorney, Mr. Stevens, is that right?
Yes, sir.
You understand that if the court approves this, your conditions of community supervision would be amended to require you to participate and successfully complete the ISP or intensive supervision program.
Yes, sir.
You understand what that requires and entails?
Yes, sir.
All right, Ms. Wiggins, has anyone threatened, forced, or pressured you to make you feel like you had to agree to amend the conditions of your community supervision?
No, sir.
You want the court to approve this?
Yes, sir.
All right, court will grant the state's motion to withdraw, the motion to revoke. The court will amend the conditions of community supervision. Do you have a motion to pay, Mr. Stevens? All right, Ms. Wiggins, I've signed this. Hold your meeting with Officer Mature, should be further instructions. Trevor Roden. All right, Mr. Roden, if you will, sir, raise your right hand. I'm going to place you under oath. Mr. Roden, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Yes, sir. All right, you may put your hand down. You are Trevor Roden, is that correct?
Sir.
And that's spelled R-O-T-E-N.
Yes, sir.
And Mr. Roden, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with Mr. Stevens' representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Stevens, you believe your client to be competent today?
Yes, sir.
And you've explained to him his legal rights and you believe he understands them?
Yes, sir. I have explained it.
All right, Mr. Roden, it appears that you have been charged by indictment with theft of property greater than or equal to $2,500 less than $30,000, which is a state jail felony. It appears that the plea agreement in your case is that the prosecution would proceed under section 1244A of the Texas Penal Code, which means that the degree of the offense would be a state jail felony, but the punishment would be that of a misdemeanor, which means that the maximum range of punishment would be up to 365 days in the county jail and a fine not more than $4,000. Do you understand that range of punishment?
Yes, sir.
I see the plea agreement that you've reached with the state is that you would receive a conviction. In this case, your punishment would be 155 days in the county jail. You would be issued credit for all 155 days for the time that you've previously spent in jail on this charge, and you would be ordered to pay a fine of $500 plus your court costs and reimbursement fees of $590. Is that your understanding of the plea agreement, Mr. Roden?
Yes, sir.
Yours as well, Mr. Stevens?
Yes, sir.
All right, understanding the charge and the plea agreement, Mr. Roden, I ask you at this time, how do you plead to theft of property greater than or equal to $2,500 but less than $30,000?
Guilty.
And Mr. Roden, has anybody threatened, forced, or pressured you to make you feel like you had to plead guilty today?
No, sir.
All right, court will accept Mr. Roden's plea of guilt. Mr. Stevens, any objection to the state's evidence?
No.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No.
From the defense?
No.
All right, the court's reviewed the evidence, and I do find there's sufficient evidence to support the plea and to convict Mr. Roden. Court will follow the plea agreement in this case. Court hereby convicts Trevor Roden of theft of property greater than or equal to $2,500, less than $30,000. Court punishes him under section 1244A of the Texas Penal Code at 155 days in the county jail, with Mr. Roden receiving credit for all 155 days for time previously served on this case. Court orders him to pay a $500 fine, $290 court cost, and reimbursement fees of $590. Mr. Roden, are you paying off any of your fine or reimbursement fees today?
Sir?
Are you paying off any of your fines or reimbursement fees today?
No, sir.
All right, then as soon as you leave this courtroom, I want you to go down to the end of the hall, going that way west, get to the last door on the left, and then you're going to ask to speak with Miss Bonnie LaPrade, and you need to set up arrangements on how you're gonna discharge your fines and reimbursement fees. Failure to do that and failure to comply with the agreement will result in me issuing a warrant for your arrest.
Yes, sir.
All right, Mr. Roden, you hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted.
That's it for a copy, Mr. Judge.
Anything this afternoon?
Yes, sir, I do.
All right, we'll see you soon. Thank you, sir. Is it Piscotta? Am I saying that wrong? Derek Piscotta, CR 2130. Mr. Woodwine, would you sign this for me? Yes, Judge. All right, Mr. Piscotta, this is cause number CR 2130. Mr. Piscotta, go raise your right hand and place your oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, let me put your hand down. You are Derek Philip Piscotta, is that right?
Yes, sir.
And Mr. Piscotta, the court has previously heard your case and placed you on deferred community supervision in this matter of possession of controlled substance in penalty group 2 less than 1 gram. Is that correct?
Yes, sir.
Mr. Smith, do we have a motion to adjudicate? Because I know the judgment says that he's pleading true to the motion.
Judge, this is the defendant's request to adjudicate. The state is not bringing a motion. He has not violated his probation.
I wonder if we should just strike this and plead a motion to adjudicate the judgment.
Say again, Judge.
I wonder if we should just strike this plea, plead a motion to adjudicate as true, because I'm not going to be asking him.
Strike the true and just write request. Request for adjudication. State's fine with that, just to make it clear.
I think that'd be fine, Judge. And ultimately, the state's correct. We have requested final adjudication. And ultimately, we'll be pleading true to that request. This is about it.
It's not a motion to adjudicate, it's the defendant's request to adjudicate. We're not bringing this to defense it, so however the court feels comfortable that to make it clear is fine by the state.
I don't suppose either one of you gentlemen have a hard copy of the order placing him on that shows the dates that we put him on supervision. Do I have any of that? I mean, I can pull it up if you don't.
I do not, Judge. I don't.
All right, Mr. Piscotta, sorry for the delay. So it appears that on October 12th of 2021, you came before the court on this charge and you pled guilty to a lesser included offense of possession of controlled substance in penalty group 2, less than 1 gram. The court entertained a plea agreement between you and the state. The court followed the plea agreement. The court deferred a finding of guilt, placed you on community supervision for 3 years, ordered you to pay a $2,000 fine, $180 restitution, court costs of $290, and reimbursement fees of $35. Is that correct?
Yes, sir.
Have you discharged all of your fines, court costs, reimbursement? Have you paid off all of those?
I paid everything besides the $180 probation fee,
$180.
reimbursement fee. And I'll have it paid by the end of the month.
All right, and so this case is somewhat unique in that the state of Texas, through their attorneys, are not requesting that this court conduct a hearing to find that you've violated any term or condition of your community supervision. It's my understanding, however, that you are asking this court to adjudicate your guilt. That means to convict you of the offense and to revoke your community supervision, sentence you to the plea agreement of 1 day in the county jail with you receiving credit for that day. Is that correct?
Yes, sir.
And in this case, you're represented by your attorney, Mr. Schmidt. You feel like you've had enough time to discuss all of the legal issues and consequences that would stem from this plea agreement.
I do.
And you feel like you understand everything that you've read and signed today and the decision that you're making today.
Yes, sir.
Mr. Schmidt, you've explained to Mr. Piscotta the issues surrounding his plea today.
I have, Judge, and that's the judgment reflects an informed judgment. And certainly Scott was pleading. So that's our expectation.
Is possession PG2 less than 1 gram? Is it automatically a 1244 ARB? The problem is I don't see a 1244B reflected in the previous paperwork or this paperwork. He previously pled to deferred on a straight up state jail. It's 1244A, Judge. It's not reflected in the judgment. It says degree of offense, state jail felony. Let me show you up here. We just need to get the paperwork correct.
For calls,
It's deferred. We don't do that at the time. of deferral.
circumstances, we would ask the court. That's the plea to the 12. It should be reflected in the plea judgment, the plea agreement. I'm not sure that the level of offense is.
Judge, and I'd be happy, that is the state's agreement with the defense. It should be proceeding under 444B. I thought it was in there.
It's in the plea section.
It may not be under the degree of offense, but it should be in the plea terms.
All right, so look, I'm just gonna write that.
That's, state's comfortable with that, Judge.
All right, so Mr. Piscotta, you told the court that you understand what you're doing today, that the state's not trying to revoke you, they're not trying to adjudicate you, but this is what you want to do, and you've decided to do this of your own free will in the court. No one's pressured you, forced you, made you feel like you needed to do this. Is that correct?
Yes, sir.
And you've done this only after you consulted with your attorney, Mr. Schmidt.
Yes, sir.
All right, the court will find that Mr. Derek Philip Piscotta was previously placed on deferred adjudication by this court on October 12th, 2021 for a state jail felony offense of possession of controlled substance of group 2 less than 1 gram. The court deferred a finding of guilt, placed him on community supervision for 3 years. The court finds now at this time that Mr. Piscotta has come before the court requesting the final adjudication of his guilt in this matter, that he's been admonished of his rights, that he has received legal counsel, that legal counsel, Mr. Schmidt, is joining in with Mr. Piscotta in this request, as is the state of Texas. Court finds that Mr. Piscotta's request to be adjudicated should be granted. The court will this day accept his request, and the court will adjudicate Derek Philip Piscotta of possession of controlled substance of penalty group 2 less than 1 gram under section 1244B, as is the plea agreement between the state and the defendant. The court hereby adjudicates his guilt under that section for that offense, and the court assesses his punishment at 1 day confinement in the Van Zandt County Jail. The court issues him credit for 1 day credit for times previously served. The court orders him to pay the balance of his financial obligations and finds that the only remaining balance is $180 due and payable to the Texas Department of Public Safety. The court is signing the judgment adjudicating guilt. Have you come forward to be fingerprinted with the deputy, and then you'll be free to go. Yes, sir. I know we have a pretty large jail docket, so hopefully, I don't know if we're gonna have issues with transport or not, but hopefully we can get 10 at a time over here. Stacy, you ready? Josue Rodriguez, CR 18-503-504. Mr. Rodriguez is set for docket call today.
Yes, Your Honor. So I spoke with the DA and my client. We did go in last week, review the videos and the evidence that we were discussing. We would ask the court to set it for one last docket call where we will either plea it on that date or set it for trial on that date. We'd like to go with the plea agreement one more time with my client. Due to the nature of the offense, it's a lot of stuff I'd like to go with them. And could get one more setting for that. The DA's in agreement that this is it. There is no more settings after this.
And that's correct, Your Honor. And I would just like to state for the record with the court's information and for Mr. Rodriguez's that if it is not signed and completed at the next setting, the state will withdraw any probation offers. In this case, we will set it for trial, and there will be no more probation offers extended to Mr. Rodriguez.
Your client understands that?
He does not.
All right, court will set Mr. Rodriguez for a final docket call. Are you available on either May 10th or 12th? We can do earlier if you have conflicts.
State would prefer.
Got April 14th or April 26th.
If we could do the 26th, I understand. In court.
All right, court will set Mr. Rodriguez for final docket call April 26th at 9 a.m. Mr. Rodriguez, once you sign and get the yellow copy, you're free to go.
Thank you, Your Honor.
Jerry, Kimberly. This is cause number CR 13597 and 596, State of Texas versus Jerry Ward Kimberling. Ms. Kimberling, I see here that there's a request to amend your community supervision to extend you for a period of 2 years. It looks like you're set to expire on May 19th of this year, and this request would extend you until May 18th of 2024. Are you requesting that the court extend your probationary period? Can you tell me why?
I don't need to make my payments. I already completed the probation and I've done the 500-hour community service, but I can't get my payments paid.
All right.
No.
If I extend this, do you believe that it would give you more time to comply with all of your conditions of community supervision? All right. And Ms. Kimberling, has anyone threatened, forced, or pressured you to make you feel like you had to do this?
No.
No? All right. Court will amend Ms. Kimberling's community supervision. We'll extend it for an additional 2 years, creating a new expiration date of May 18th, 2024. All right, Ms. Kimberling, I've signed the amendments. If you'll come forward and meet with the probation officers, they'll give you more information. Bring your purse. Mr. Coleman? Okay. Mr. Coleman? Is there plea papers?
No, Judge, there was a misunderstanding. It's my responsibility. There's an unresolved issue with discovery from Harris County Probation, which is where he's being supervised in the Senate court program. The state has agreed, and it's our request to reset this one more time because we need this information. We're going to collaborate together to get it to show compliance with his probation, his hours, his fines, his drug tests, where he was being supervised in Houston, Harris County. And depending on that, the state may modify its offer, which is right now a plea of true offer, 12-month state jail. But it'll be pending the collaboration on these probation efforts, showing that Mr. Coleman has been working diligently to fix the reasons why he's before the court.
Say,
Yes, Judge. Mr. Ashmore brought these to my attention today. I'm gonna reach out to both the Senate Court facility and the other county, see if I can't get final confirmation on all of that. So we can make sure that we have a full picture of what we're doing. So we would ask for about a month to just the next contested docket, and we should have a resolution for Mr. Coleman then, or we'll have a hearing then.
all right, court will set Mr. Coleman for a final hearing on the motion or vote on April 28th. Mr. Miller, do you have an attorney on your motion or vote here this year? Is it Mr. Cazares? Okay, is he here?
It's Miss.
Mr. Alexander.
Oh, I'm sorry, I didn't.
The state filed a motion for continuance that Ms.
Oh, okay.
Waynett told me was granted and reset to the April contested docket.
Okay, yes, all right, so. Okay, so the court will set Mr. Miller then for his motion to revoke hearing on 4/28. That'll be at 9 a.m. However, Mr. Miller, I am going to UA you today, okay?
I've taken one. I've taken one while ago.
Oh, you've taken one already?
Yes, sir, with the probation officer back there.
Negative, okay. All right, good, I'm glad. That's good news. All right, so Mr. Miller, I'm gonna have you sign this form here. When you get the yellow copy, it'll have the new date on it of April 28th.
Yes.
You'll be back on that date. Once you get the yellow copy, you're free to go.
Sir, I was supposed to meet with the officer.
Sure.
Yeah, back here. Is he still back there?
Throw it back there. No, you may have to go over to their office, okay?
Yes.
Mr. Miller. Let's go ahead and close these two.
Okay.
Those are we'll leave those open
Are we done for this morning?
for this morning. Mayor.
You'll leave them open until the second?
Yeah, you got this. Then when we get going, we'll shut it down.
Yes.
Well, we've got one. more. Mr. Welch. All right, court's going to stand in recess until Mr. Michael Welch's arrival. You'll let me know. All right, we're back on the record. This is cause number CR 18-520, State of Texas versus Michael Chase Welch. Mr. Welch was set for a hearing on this motion to adjudicate today. Prior to taking announcements from the parties, the court requested that Mr. Chase be evaluated for the presence of any controlled substance or alcohol, anything that would violate his community supervision or pretrial release. Mr. or Officer Waddell, your analysis evaluation of Mr. Welch.
Yes, Your Honor.
What were the results?
The defendant was not able to produce a sample, but upon questioning, he admitted to using heroin with a needle 2 days ago.
Did he sign an offense form?
Yes, sir.
Yes, that's it. Have you shown this to Mr. Sawyer?
No, sir.
All right, thank you, sir. I appreciate it. Any questions for Officer Waddell, Mr. Sawyer?
No, Your Honor.
It's my understanding that prior to the evaluation that Mr. Welch had negotiated a plea agreement. Is that still the plea agreement that's going to be asserted to the court?
No, Your Honor, state is revoking its offer at this time. We'd ask for a reset of this cause so we can reevaluate his situation, discuss with Mr. Sawyer, see if we can't reach some resolution to this case given this new information.
That's my understanding.
All right, so I'm going to reset this case until the next contested docket date. That's going to be April 28th. If there's an agreement that's reached before then I can set it earlier. We'll just have to notify the court. Mr. Welch, based on your admission, the court's going to find your surety bond to be insufficient at this time. The court's going to revoke your bond. I'm going to set new bail in the amount of $75,000 cash or surety for your violations of pretrial release. So I'm ordering you into custody at this time. As I said before, if y'all reach an agreement on something else that's going to be dispositive of the state's motion, then just let me know. We can do it sooner rather than later.
Yes, sir.
All right, we'll take Mr. Welch into custody at this time. I've got the order. Give him a copy. If you'll have Mr. Welch sign the copy of his notice of appearance, give him a copy of that. We'll see.
I'll be back this afternoon.
That will complete this morning's docket. Court's going to stand in recess until 1:30, and the inmates will be brought over to the courthouse this afternoon.
State intends to be here as well, Your Honor.
We anticipate we'll have any contested hearings this afternoon.
I know, Judge. We have several attorneys that have not got back to us, so.
Wait, and see. All right, 1:30.